Good evening, sir.
Good evening, sir.
Good evening. Good evening, Professor Patel. Welcome to the Kerala High Court.
Good evening, sir.
Welcome to Kerala High Court.
Thank you so much, sir. Thank you.
Hope you will come here physically another time. You can come here another time physically.
Yes, certainly. It will be my honor and pleasure, sir, to interact with members of the bar and bench.
So, shall we start now?
Yes, sir.
Shall I start?
Yes, Ramona. Go ahead.
Yes. On behalf of the Indian Law Institute Kerala State Unit, I'd like to wish everyone who has joined us today a very good evening. My name is Ramola, and I will be hosting this session. Today's lecture is by Professor Bimal Patel on the International Law Commission and Shaping of International Law. I would like to invite Honorable Mr. Justice Alexander Thomas, Executive Chairman of the Indian Law Institute, Kerala State Unit, to deliver the welcome address.
Honorable Chief Justice of the Kerala High Court, Justice S. Mani Kumar, my erudite sisters and brother judges of the Kerala High Court, members of the Executive Council of the Indian Law Institute, members of the bar, Professor Dr. B.N. Patel, and all participants, a warm good evening to all of you. We are indeed honored to have Professor Dr. Bimal Patel, member, United Nations International Law Commission, Geneva, and Professor of International Law, and former member of the Organization for the Prohibition of Chemical Weapons in our midst today. Professor Patel received his postgraduate qualifications in international relations, foreign policy, and government from the University of Oslo, Norway, postmaster's qualification in international relations from the University of Amsterdam, and postgraduate diploma in international relations and development from the Institute of Social Studies, Hague, Netherlands. In 1995, he acquired his Master of Arts in international relations from the University of Amsterdam, and in 1999, he secured his LLM in international law from the reputed Leiden University, Netherlands. Subsequently, he has acquired 2 PhDs in international law. The first one from Jaipur National University in 2013, and the latter one in 2015 from the Leiden University, Netherlands. Dr. Patel has served as director of the reputed Gujarat National Law University, Gandhinagar, for 2 consecutive terms during the period 2008-2019. And during his tenure, he has started many new courses and innovative programs and had transformed the academic system of GNLU by adopting the research-based teaching university curriculum. He served as a member of the 21st Law Commission of India, headed by Justice B.S. Chauhan, former Judge Supreme Court of India, and he was also one of the lead academic advisors to India for India's tenure as a member of the UN Security Council 2021-22, and he's also a member of the editorial board of the Journal of the International Committee of the Red Cross, Geneva. Professor Patel served the Organization for the Prohibition of Chemical Weapons, OPCW, Hague, between 1995 and 2009, and has researched on the jurisprudence of the International Court of Justice, the International Tribunal for the Law of the Sea, the International Criminal Tribunal for former Yugoslavia, and the Administrative Tribunal of the International Labour Organization. He has delivered lectures at various international universities, including Cambridge University, and was specifically invited to address the World Ocean Science Congress. The United Nations and the Government of India have consistently engaged Professor Patel to act as advisors to many institutions and departments where he has been deputed to draft both international, national, and state level legislations like the Antarctica Act, the Deep Seabed Mining Act, the Anti-Piracy Bill, etc. It is indeed a great pleasure to have such an eminent academician in this lecture. Dr. Patel, your expertise and insights will indeed be valuable to our audience, and we are excited to hear what you have to share. Thank you for taking the time to join us and for sharing your knowledge and experience with us on the International Law Commission and the shaping of international law. We know our audience will greatly benefit from your presentation. Once again, welcome and thank you for being here.
Thank you, sir, for that warm welcome. We are truly privileged to have such an eminent scholar amongst us today. But before we begin the lecture, as you're all aware, today's session is being live streamed on our YouTube channel and will also be available for subsequent viewing. I'd like to mention that there will be a short question and answer session at the end of this lecture. So the audience may send their questions to Dr. Patel using the comment section on the YouTube channel. So now, without further ado, I pass the screen to our esteemed speaker to discuss the International Law Commission and shaping of international law. On to you, sir.
Am I audible now?
Yes.
Yeah.
Okay, I'm sorry for that. Jai Hind and a very good evening. At the outset, I would like to thank Honorable Justice C. Thomas, the Executive Chairman of the Indian Law Institute, Kerala, for inviting me to talk on this topic of International Law Commission and the shaping of international law. I'm equally grateful to my former colleague, Dr. Sikharanjan, who spoke to Judge Thomas, and subsequently I'm here. At the outset, I would also like to mention that I'm very grateful to my country, India, for nominating me as a member of the International Law Commission and the entire international community of states who have given me the huge mandate. As you might be knowing, as many as 163 states voted, setting a record in the history of 75 years of which India has been a member throughout almost, to give that shows the enormous amount of faith of the international community towards contribution a member can bring for the codification of international law and progressive development of international law. I consider it is a great privilege, but at the same time also accountability, because as the world goes through newer challenges, the complexity, the scale and scope of each challenge either increases or differs. The international law has to keep pace with those changes so that the International Law Commission and the Sixth Committee of the United Nations General Assembly, which I consider are collectively charged to contribute to shaping of international law or to clarify international law with the help of international courts and tribunals, can fulfill the principles and objectives of the UN Charter. So it is very exciting, but at the same time, I can say it is very, very accountable job, because as a member of the International Law Commission, each individual member is individual expert in his or her own capacity and directly responsible to the Commission, through the Commission, to the General Assembly of the United Nations. In other words, each member of the Commission brings expertise, contribution of international law, while he or she may have a particular expertise in one sector of international law. He or she is also expected to actively contribute to other areas of international law as well, which might be considered by other colleagues in the Commission. Currently, there are 34 members who have been elected into the International Law Commission for the duration of 23 to 27. It is for the first time that 19 members out of 34 have been elected from Asia and Africa, including 2 members which I consider they're actually from African Asian origin. They will be in different parts of the world. Why I'm saying this? It has acquired certain significance because the international law has been, one can say, requiring the legitimacy of universality as far as its content and form was concerned. And the regional approaches, the doctrines, the state practice, and the case law of each of the African, Asian, Latin American countries remains very important, because only when all these countries of Africa, Asia, Latin America, and if you may say Global South would contribute actively to the development and clarification of content and form of international law, it becomes a universal language. And as I say, international law is connecting countries. So I say with enormous amount of faith and responsibility that international law is there to connect countries. It cannot simply impose its will, because as we all know, the will and consent are the 2 fundamental principles of international law. And international law develops, international law gets codified, provided all 193 member states of the United Nations, and where it involves non-state actors, it could be international organizations or other stakeholders, their understanding, their acceptance, not formal acceptance, but acceptance, tacit acceptance, is very important. Because international law can only serve the international community if it has been accepted voluntarily, and as I said, with the view of consent. And then becomes very important that it can be enforced. So these 34 members of the International Law Commission, they meet approximately 10 to 11 weeks in 2 sessions, in 2 parts in Geneva, and each of the member will be part of one or other working group or study group, and they will be actively participating in those working groups and study groups. And these groups, the rapporteur, the chairman of the commission, they address the outcome of the commission in the 6th committee when it meets, generally speaking, towards the end of October or November, beginning of November of each year in New York, during the normal session of the General Assembly. As far as the format of the commission is concerned, currently out of 34 members, the 5 members, each representing one region, becomes a chair, vice chair, chairman of the drafting committee, and each regional group appoints one member to this bureau. In other words, the commission tries to attain every single decision by consensus. How to look for, but I believe that in the last 79 years of history of International Law Commission, all the decisions have been taken by the consensus. Why I'm saying, why I'm focusing this importance? Because when the decision on either the norm, the content, or the report has been achieved by consensus, it acquires the highest amount of legitimacy. The International Law Commission reports and also the works are extensively used by the states, by the foreign ministry, by the legal advisors in the foreign ministry, International Court of Justice, International Tribunal for Law of the Sea, but also various international courts and tribunals, regional courts and tribunals, international organizations, even non-state actors. In other words, the consensus and the representation of main form of civilization in the commission are two important pillars, two fundamental pillars, not only of its legitimacy, but great acceptance in all the international law actors. And therefore, there are, as we all know, international law societies, international law bodies, forums, etc. But the International Law Commission, which is a subsidiary organ of the General Assembly, acquires a preeminence because it is the member states who puts faith in the election of the members of the commission, and the output of the commission's products will become tool for understanding, clarification, negotiation. In other words, the products of International Law Commission facilitates to a great extent the international relations between states and also through the United Nations, between United Nations and member states. And that is how it at the end serves the purpose of realizations of principles and purposes and objectives of the UN Charter. Therefore, the work of the Commission is both from the content, from the form, and from the process purposes highly valued by the Supreme Courts of national states as well. Having said a bit about how the Commission works, I would go down to what the Commission has achieved so far in the last 79 years of history. So here, I would just go through various areas. First of all is the law of the treaties. The International Law Commission has made, perhaps in my view, the most significant contribution as far as the law of the treaties is concerned. The topics which the Commission has completed are the treaties that are concluded between the states and international organizations. As we all know, member states, to facilitate international relations among themselves, conclude hundreds of bilateral treaties and hundreds of multilateral treaties as well. The United Nations Secretary General himself is a custodian of few hundred multilateral treaties as a depository. So this is a very important contribution which the Commission has made. The Commission, the ILC, the International Law Commission, when I say Commission, it is the International Law Commission, has also concluded its work. To my colleagues from the area of private international law, commercial law, trade law, the two important topics, that is most favored nation, part 1 and part 2. Though the Commission by and large, in my view, deals with the classical areas of international law, general public international law areas, most favored nation MFN clause, which we find generally also in private international law, has been the byproduct of or the product of the International Law Commission. The International Law Commission has also contributed ways and means for making the evidence of customary international law more readily available. Customary international law, including in the Indian Constitution, we know is consisting of two important elements: the state practice, opinio juris sive necessitatis. So, how a particular rule can be considered a customary international law which is binding to entire international community, and how to find the ways and means so that we can say that yes, this is an evidence that a particular norm has become customary international law. This is again a work which the International Law Commission has concluded. India, and like many countries, do sign, ratify number of treaties. But at the same time, it is perfectly possible a state while signing a treaty would also feel uncomfortable with regard to certain clause or sections of a treaty. And as I said in the beginning, will and consent are two important components of any states taking obligations under international law. So the International Law Commission worked upon the topic called reservation to multilateral conventions. So for example, India has signed, ratified the United Nations Convention on Law of the Sea. But at the same time, the convention allows all the countries who are parties to the convention to make reservation or a declaration. Of course, those reservations and declarations shall not undermine the object and purpose of the treaty. That is a different topic altogether. But important thing is, for example, while the state may agree with all contents, but if a dispute arises out of interpretation or application of a treaty, a state may prefer a different mechanism than what is prescribed in a particular treaty. So this is an excellent case where, for example, as I said, the government of India on 29 June 1995, while becoming a party to the United Nations Convention on Law of the Sea, attached a declaration as to how disputes, if that arise during the implementation or interpretation of one clause, can be settled. Now, this is again a work of the International Law Commission. So that is how the International Law Commission has shaped. Again, very important topic which the Commission has dealt with is fragmentation of international law. Earlier, the international law was known to very few people or very few countries. But now international law has become a vehicle of the growth and development of even an individual. Because when ILC was envisaged back in 1940s, late 1940s, at that time we all know, largely it was believed that individuals are not actors of international law. But actually the international law is meant to facilitate the overall growth and development of an individual human being under the UN Charter. So over the last 80 years, international law has become synonymous with, without giving direct rights, and of course there are mechanisms available as far as the invocation of individuals' rights under a particular treaty is concerned. It has provided means to an individual if directly or indirectly an individual right by a state or by an international organization has been breached. And therefore, originally the international law was meant for the states. But as I said, now it is states, international organizations, individuals, corporates. In the process, there has been what we can consider fragmentation of international law. So there is the cohesiveness of the international law at times remain little bit ambiguous. What is international law, or what is the rule of international law on a particular very subtopic is concerned? For example, till 1998, we did not have a multilateral treaty on international criminal law. And following the great work which Commission did on Nuremberg principles, from 1948 till 1998, almost 50 years, the world community was desirous that grave violations of international law shall be brought to the books. But it was the Rome Statute and now the International Criminal Court, completely different treaty. Now, under that Rome Statute, the ICC has a jurisdiction. I will not go into that. But till that time, we had only the International Court of Justice, which enjoys the universal acceptance, and it is the most important, the principal judicial organ of the United Nations. But with the establishment of the International Criminal Tribunal for former Yugoslavia, for Rwanda, the first of its kind multilateral criminal court, and various commissions and courts and tribunals dealing with heinous crimes against under international criminal law, under humanitarian law, under human rights law. So in the process, all these commissions and tribunals would interpret the international law as per their statutes. Of course, they would keep in mind the overarching framework of international law. And of course, they will keep in mind what the International Court of Justice had to say. But at the same time, their purpose is to settle the disputes that have been brought before them by those parties. So during the interpretation phase, during the clarification phase, during the dispute settlement itself, we often find that there is some sort of incohesiveness as far as pronouncement of international law is concerned. The International Law Commission, taking cognizance of this emerging area of fragmentation of international law, has also done enormous work how to reconcile those difficulties which arise because of the diversification, as I mentioned, and also the expansion of international law. Currently, the Commission is dealing with three very important topics of treaty laws. One is the provisional application of treaties. Now, provisional application of treaties, in very nutshell, one can say, generally treaties come into force. I'm really referring here multilateral treaties come into force when, as per the treaty, number of member states or parties sign and ratify a treaty. But at the same time, number of treaties currently in existence have not entered into force. And there are treaties where number of states would like to be bound because they have been actively participating. So while the treaty will come into force at future date of time, these states would like to be bound by the terms and conditions they have accepted when they actively participated in the negotiations of and conclusion of the treaties. So one thing is the conclusion, another thing is the entry into force. So the Commission is currently seized off with how to deal with this issue or topic called provisional application of treaties. Similarly, the Commission has also considered the peremptory norms of general international law. And my friends and colleagues of international law can easily recognize what we call jus cogens, because these are the norms where there is no derogation possible in whatsoever circumstances. For example, slavery, racial discrimination, to extent torture. Now, there are certain norms which are considered to be crimes against humanity, war crimes, crimes against peace, crimes of aggression. I'm not labeling whether those are jus cogens because, as I said, these are under consideration. But the Commission has identified those crimes or those norms of general international law from where there cannot be a derogation possible. And of course, this requires unanimity. Whether a country X believes that a particular norm is jus cogens or not may not be agreeable to country Y. And therefore, when the commission brings out, so like a researcher, like a scholar, like a jurist, you study the law, you catalog them, you organize them, and you put it in a very simple, easily understandable format, present it to the sixth committee of the member states, and the sixth committee then debates whether the product that has been produced by the commission is what? Reflective of codification or is reflective of progressive development now. And then once the states agree, so next form could take place. They would simply accept it as a resolution. They might say, okay, fine, these are the draft articles. It can be considered in form of a new convention or treaty, or simply they can be considered as guidelines, etc., etc. So again, the product of the International Law Commission, even with regard to the peremptory norms of general international law, are subject to the discussion among the member states. But it is very important to note that while the member states could deliberate on this, the work which is done by the commission, we have found that it is being already used by the international courts, tribunals, member states, etc. So why I'm emphasizing this point? Because every single work of the commission achieves a huge amount of, one can consider, legitimacy and credibility, because that represents, in my view, the conscience of the entire international community. The third topic, again, is the general principles of law, which is under being considered by the International Law Commission. So, for example, even in general principles of law, the way it emerges, we all are aware of rules, substantive general principles of law, but also procedural principles of law. But as far as the international law is concerned, Article 38(1) of the International Court of Justice statute, which generally is considered to be the sources, may not be considered to be a source per se, because it is only the four means for which settlement can be done as per reference by the member states. But very importantly, is it talks about the general principles of law as recognized by civilized nations. So civilization, I don't get into this particular terminology because it has its own controversial issue. But very importantly, what are those general principles of law which are accepted across all the countries, whether it is common law, civil law, and also the civilization. And again, those are the principles, as I said, now being discussed by the General Assembly, by the Sixth Committee of the United Nations. Again, this is work which has been done by the International Law Commission. While I talked about the sources of international law, it is very important the subjects of international law. So we all know that states are the subjects of international law. But as I mentioned earlier also, it is not anymore the states, it is an individual as well. Gone are the days where individual cannot even think of bringing a state before an international court or tribunal or regional court and tribunal, particularly in the areas of private international law, in the areas of international criminal law, human rights law. More and more international regional commissions, courts and tribunals, including quasi courts and tribunals and commissions and bodies, have come up, giving access to individuals, natural persons, also legal persons, if they believe that under a particular international law, their rights have been breached. Now here, as far as the states are concerned, the most important work one comes to know about International Law Commission is international responsibility, the articles on responsibility of states for international wrongful acts. Now, shortly it is called RCWA. This work of the commission, which has been, I would say, as long as since Permanent Court of International Justice, of course, that time we did not have the International Law Commission, but from the very first day of the International Law Commission, this work has been under progress. So in 2001, as I call RCWA, has been adopted by the United Nations General Assembly. So it is in form of resolution. But these articles, the work of the commission, has been found in the records and references, citations, not only of international courts and tribunals, but to a large number of investment arbitration tribunals, whether it is Permanent Court of Arbitration, with the International Chambers of Commerce, whether the jurisprudence of WTO. In other words, as international law students and scholars, we say the treaty is the international law, but certain products of ILC have acquired the status of highest credibility, and the RCWA is one of them. So a state, in very nutshell, if state commits any wrongful act under any international law of which it is a party or it has undertaken obligation, then there is a consequence for that. So there is a breach leads to attribution, and if an attribution is made to a particular state or state organ, then there are consequences. How to address those consequences? So there are reparations, could be material, non-material. In other words, the greatest contribution as far as the soft law of the commission is concerned, one may consider it is the International Law Commission's work on international wrongful acts committed by the states. Another important topic which the commission has shaped over a period of last 8 years is the international organizations. Currently, we have thousands of international organizations in context of India itself. Earlier, India had only the Asian African Legal Consultative Organization. But as India starts hosting international organizations such as International Solar Alliance or International Center for Ayurveda and alternative means of rehabilitation, and there are a number of small and big, known, unknown international organizations of either truly international character, of truly regional character, of truly of multilateral, in which there may be more than one state or state and international organizations are parties. And international organizations are part and parcel of the international life. And obviously, there can be issues, difficulties between states and international organizations, between international organizations and individuals. So the whole spectrum of international relations of these entities required to be codified. And as I said, if there are issues with regard to the clarification, interpretation, implementation, how to resolve those issues. So here, the important contribution of the ILC comes into play. And that is basically the representation of states in the relations with international organizations, the responsibility of international organizations, the status, privileges, and immunities of international organizations, their officials. Now, those are the issues which international organizations are day-to-day required to understand. So those have been also contributed by international law commissions. When we are talking of individuals, so I said states, when I'm talking the subjects, states, international organizations, then position of individuals. I briefly mentioned to you about the Nuremberg principles after Second World War. Now, the International Law Commission formulated the Nuremberg principles to a great extent that one can consider has become the foundation of what today we are seeing, the Rome Statute or International Criminal Court, and it has also been referred not only by the International Courts and Tribunal, but national courts and tribunals as well. Here, the Commission has, as I said, codified the position of individuals in international law. Another important topic is nationality, including statelessness. So when we find millions of people without nationality, how to deal? Because as I said, we are talking of their rights, their duties, and also the rights and duties of the states whom they originally belong to. So the Commission has also worked upon the issues of nationality, including statelessness. The Commission has also worked on the protection of persons in the event of disasters. So you could imagine the Commission's work has, from individual level to the global level, has tried to codify every aspect, and the work I would still consider under progress. Similarly, I briefly mentioned to you about international criminal law. Nuremberg principles, which I mentioned to you, the question of international criminal jurisdiction, the draft code of crimes against the peace and security of mankind, and very importantly, the Commission concluded its work on crimes against humanity. Now, this particular work, which has been prepared by the Commission, was referred to the 6th Committee of the General Assembly of the United Nations. And last year in November, a resolution passed under which Secretary General was called upon to explore options to consider how to go forward with regard to giving a particular shape to work, the draft articles on crimes against humanity. Should it be a form of a new treaty, convention, or what? It is very important to know the Commission is made up of individual experts. Though individual Commission member ensures or attempts to ensure that regional approaches, universal approaches, the needs, concerns, and interests of states are reflected in its work, in its commentary. But at the end of the day, it is the member states which would give it a kind of a formal legitimacy. And what could be a formal legitimacy? As I said, if the product of the Commission is accepted, and there are number of mentions which I just told you earlier that have become part of international treaties, and that can also become resolution, unanimous resolution of the General Assembly. And therefore, it is very interesting to see how now the work of the Commission is over as per the crimes against humanity is concerned. How the international community of states would take it, whether the Secretary General would convene a conference of the plenipotentiary, that is up to the member states. We may hope that certain outcome as far as the crimes against humanity is evident, because those are the issues which clarifies the positions of individual in international law. Of course, a huge spectrum of law of international space one can consider. Which are those spaces? So first and foremost, the law of the sea. So the United Nations Convention of Law of the Sea, one can consider is international space. Now, this is an area where the Commission has made a huge contribution. Similarly, the Commission has also worked upon the law of non-navigational use of international water courses, the law of transboundary aquifers. Similarly, there are currently topics under consideration, and those are, in fact, in the last General Assembly session and 6th Committee session, the report of the Commission on Protection of the Environment in relation to armed conflict, protection of the atmosphere has been discussed. Very importantly, currently, the Commission is dealing with the issue of sea level rise in relation to international law. Again, as we know, the sea level rise, climate change, currently there are advisory opinions being sought from the International Tribunal for Law of the Sea, International Court of Justice. The importance of Commission will be also there, as the Commission deals with the sea level rise in relation to international, though they're separate, one can say, but the debates, the statements would certainly reflect. In the process, the Commission not only studies, appreciates the work of the states, because by and large it is, as I said, a body which is composed of elected by the states, international organizations and other actors. So it is very important, those actors which have huge say in sea level rise, they may be discussing at various fora. For example, let's say the work of International Law Association, the work of Institut de Droit International, and similar organizations which are also simultaneously discussing the same topics which are also discussed by ILC. So the ILC benefits, the Commission also benefits from the great work. For example, Institut de Droit International, now that is much older body, established in 1904. So the ILC also appreciates, gets benefit of the views of the Institut de Droit International. So the states, international organizations, and the commissions and associations made up of professors and jurists and judges of international and national courts and tribunals. So sea level rise, I'm saying this because this is a topic, sea level rise is a topic which not only affects the states, but individuals, institutions, and alike. And therefore, the contribution of all these actors are very important, and they're being studied. It depends what amount of weightage to be given, whether a particular position of an international organization or an individual or a particular national court is reflective of international law or not. That is a different matter. That is what precisely the ILC does. So even in the sea level rise, this is what the Commission will be looking at as it continues its work. There are, again, number of areas, for example, settlement of disputes. Again, these are areas where dispute settlement between international organizations are concerned. The Commission is now being seized with settlement of international disputes to which international organizations are parties. So this particular Commission, which has just started functioning from 2023, it has before its very important topic, succession of states in relation to state responsibility, sea level rise, the settlement of international disputes to which international organizations are parties, the rules of determination of international law, subsidiary means to determine the rules of international law is also before the ILC. And also very important, piracy and armed robbery. As Rumila mentioned in the beginning of this lecture, I had been associated with the drafting of the bill on the piracy bill, and very happy to know that the Parliament has enacted, and now it has become the Act. And it is a matter of sheer honor and pleasure to see how Government of India has reflected, keeping in view its own positions with regard to the topic, and still in consonance with its obligations, whether under UNCLOS, that is United Nations Convention on Law of the Sea, or international law which has effect on its relations as far as the law of the sea is concerned, how it has reflected all its obligations under this Piracy Act, Anti-Piracy Act as it is. So in nutshell, what can say, the International Law Commission in its last 80 years of existence has codified. So codification means what is law or what is international law. And it has also contributed the progressive development in international law, what ought to be law or what ought to be the norms. So lex lata and lex ferenda, as is called in Latin term. And also in terms of international relations, how it has navigated the difficult position of one hand, international law also wants to ensure stability, but also the change. Because as the states move on, as the international community grows, as the aspirations of individual grows, there are new realities. And how the Commission adapts to these realities and aspirations of states, international organizations, and individuals, it's something what I call the stability and change. And this is how the Commission makes its contribution and shapes the international law, which becomes useful to not only to the states, to international organizations, international courts and tribunals, but every single courts and tribunals. Because at the end of the day, every state member of the United Nations, we all uphold the rule-based international order. We all are small country, big country. They all are part of the same charter. And in their relations, they always try to uphold the rules of international law. And it is the Commission, the International Law Commission, which makes a huge contribution in assisting the states, in assisting international organizations and individuals to tell what the international law is and what the international law should be. So in nutshell, this is what International Law Commission does, will be doing, how it has shaped international law. Directly, indirectly, every one of us is being affected. And as I said, to realize the charter ideals and objectives, the Commission plays a very vital role. And it is one of the finest instruments which the independent experts has, and through which it aids the government and international community. So I consider it is a great privilege for me to talk to you about my understanding of International Law Commission, how it will grow in future. And if you have any questions, comments, suggestions, I would be very happy to answer them. Thank you so much.
Thank you so much, sir, for that very interesting session. I think you have captured the key role that the Commission has played in shaping and forming what international law is today. So we are very grateful for that. There are a few questions, sir, that have come in the chat box. If I may read them out to you. So you have spoken about the Law of Sea Convention. So one of the questions that has come in that, actually there are two questions in that context. The first is that contiguous zones in Indian Maritime Zones Act varies from contiguous zones as laid down in the UN Convention on the Law of Sea. It provides for security interest in the Indian context. Do you think such a diversion in Indian law from the International Convention is permissible? And if so, what are your thoughts on that?
So first of all, let me clarify that the contiguous zone, which is defined in our Act as well as in the UNCLOS, are in consonance. So there is a 24 nautical miles from the baselines. India in its practice, I'm using word in its practice, upholds this 24 nautical miles. If Indian law would have been in divergent as far as the practice is concerned, there would have been many, many more difficulties and disputes. But India upholds this overall framework of 24 nautical miles. And as far as the contiguous zone, which is actually an adjacent to the territorial sea or territorial zone as it could be called, contiguous zone, the country doesn't have the sovereignty, the sovereign right which it enjoys. So India also enjoys sovereign rights as far as the contiguous zone is concerned. So I can say that our practice is in consonance with the UNCLOS of 24 nautical miles, which is very well defined in the convention itself.
Yes, thank you for clarifying that, sir. A second question in relation to the law of the sea, and as you had pointed out your role in developing the law on privacy. One of the questions that has come is that with the subsequent convention, which is the SUA Convention of 88, does the definition and meaning of piracy under the Law of Sea Convention have any more relevance? And if not, if it does, how would you read both of them together?
Yes, it is going to be a challenge. Even if you look at the Article 101 of the UNCLOS itself, the piracy that was defined in 1982, and which we all know that piracy is a universal crime. So I'm not getting into the substance of that. But the 1982 convention definition, piracy itself, has undergone, I would say, substantial changes as far as the practice is concerned. That time, the different spaces were not known to the international community. And it is because of, I would say, ambiguity, which was there in 1982, the 1988 convention came into play. So when, as far as convicting the persons under the SUA Convention, India is one of the parties of SUA Convention as well, it overrides. But I would not give a blanket approval, so to say, that it overrides the Article 101 of the UNCLOS, because you are a party to UNCLOS as well as you are a party to SUA Convention. So what our judiciary does, and this is exactly what is happening. Any country, whether it is Indian Supreme Court or any Supreme Court in the world, they would like to harmoniously construct the two laws where they believe that there is possibility gap, and the judiciary will pronounce its verdict. So our judiciary, for example, now that we have Anti-Piracy Act, we are also SUA, and we have the UNCLOS. I could very well envisage 5 years down the road, there will be certain disputes which will be before our courts, where it would require to harmoniously interpret not only the national law, but also national law in conjunction with international law. Now, this is exactly our judiciary will be doing. And we have to appreciate that SUA Convention is a separate convention altogether. UNCLOS reflects by and large what we call custom international law. But SUA Convention was meant for specific purposes. It depends when a country, when it brings an individual or when a country brings a state before international courts and tribunals, whether that country would like a court to adjudicate the dispute under SUA Convention or under UNCLOS. Because let's keep in mind, it is the countries or the two countries, if they refer a matter to the court, they would expressly tell the court how they would like the court to settle the dispute. They would say in accordance with 1, 2, 3, 4, 5. So for example, the country may say that we both are members of SUA Convention, right? And a dispute has arisen between state A and B. And then the International Court of Justice or Tribunal will look into both obligations undertaken by both states under SOA Convention as well as UNCLOS, and then they would adjudicate. So the purpose of referring a matter to the International Court and Tribunal is different than what we call is the simple law. So that I would like to clarify.
Thank you so much, sir. Another question that we have received is in respect of the International Criminal Court. The first part of that question is, why has India not joined the International Criminal Court or the Rome Statute? And if it hasn't, is it helping India in any way?
So again, as I very beginningly said, the will and consent. So no, why India has not ratified, it is the prerogative of a sovereign, whether it wants to ratify or whether it wants to sign, and even after signing, it wants to de-sign. It is a sovereign prerogative. So we cannot, no international community, no state can force, because any pressure or any coercive signature cannot yield, the consent, so to say, of a state to be bound by international law. Having said this, while it is a stated legal position, it depends whether a particular, in this case, Rome Statute or so, if a country believes, in this case, it could be India, if it believes that its concerns or its interests are not validly protected under the ICC or Rome Statute, no country can bind India to be bound by forced to sign the statute. So it is as simple as it is. Having said this, there are substantive provisions in the ICC statute itself, for which not only India but other countries have also raised concerns, and as a result, India has not remained a party. And India also believes we are the largest, the most ancient civilization in the universe. So we have our own courts and tribunals to adjudicate all matters which are under, under our IPC, CRPC. And in order to protect its interest at global level as well, India wants to make sure that even while we are not party, and keep in mind, a state doesn't have to become a party to a particular statute, in so long as it fulfills its obligations in spirit. This is what precisely India does. India may not be formally a party to ICC statute, but India upholds our judiciary, our executive. They try to uphold the principles, the objective and purposes of international criminal law, which in my view is far more important than a formal, signing a particular treaty.
Yes, I think you clarified that perfectly. One more question, sir, on India's participation in general, though it's a very active participant. One of the questions is that why has India not provided any written views or answers to questionnaires or information on its state practice, except for 2 note verbals as early as in the 1950s?
I think this needs to be corrected. So, for example, I can tell you, if you go to 2022 session of the 6th committee, you will find that Government of India, speaking to the Ministry of External Affairs, have clearly laid down its position, what we call the written statements. So all the records of India, when it speaks in the commission when it talks in the 6th committee, they are very much available in the public domain. Number 2, if we, for example, India was a party to, India was a non-permanent member of the Security Council, you can very nicely find the great work which our mission in New York does. Every statement made by PMI before any of the committees or organs of the United Nations are well documented. Explanation of votes is there as well. So perhaps earlier that was not the case, but now the amount of information which is available as far India's position, not verbals, everything is concerned, is available in the public domain. So I think it is is a requirement. One has to do extra amount of research. So there is a general perception, and I think that perception I most humbly suggest that should be removed, and one should go and look into those websites of the countries. If it may be possible, it may not be possible on the, let's say, the website of the Indian mission, but if you go to the website of the Sixth Committee, it is there. So it is a platform which country uses. So I would say it is transformational. Because I've been benefiting and I've been reading without visiting the Foreign Ministry library. Every information one can say are available on the website of various organizations, various platforms. They are available, including if you look at the report of the External Relations Committee, everything is available there. But one has to do research before building a perception, I would say.
Yes, I think you're absolutely right, sir. I have two more questions for you. The next question is, you had spoken about sources of law, and that's where this question comes from. Does the International Law Commission consider teachings of highly qualified publicists as a source of international law?
So let me clarify one thing. Nowhere in the charter there is a term called source of international law. So if you look at the Article 38(1) of the UN Charter, it talks about dispute, and these four sources, A, B, C, D, they are simply four stated areas which state can use only for the limited purpose, I'm telling you, for the limited purpose of dispute settlement. But the sources of international law are varying, hundreds and hundreds, right? So for example, bilateral treaty may not be expressly mentioned in that Article 38(1). But for example, India, when India deals with, let's say, any other nation, the bilateral treaty between that state itself is a source of obligation. So it is how country derives its obligation. That is more important. And I think that misnomer, which is widely prevalent, and I also use in my teaching, so that misnomer has to be removed, number one. Number two, to your specific query about teachings of the highly public jurists or qualified writings of the teachers, it does have, I would say, certain persuasive value. The reason being, one source, how I learned position of India. One is a state when there is a not verbal or a pronouncement by the judiciary, but at the same time, a jurist or a scholar would very systematically and scientifically study country's position on a particular area of international law. And then he would or she would classify, categorize, organize, and the outcome of a study of a jurist could have much more persuasive value in understanding what a particular country's position on international law is concerned than simply a position of the state. Keep in mind, because state is not just executive. It is executive, judiciary, parliament, and also teachers, scholars, jurists who write and who try to clarify that this is what the apparent position of the government is. And then the International Law Commission gives a particular weightage to understand objectivity, impartiality, independence, all these things. And then it quotes, but again, the writings, though they might be extremely highly educated, objective, neutral jurists, but there is always a caveat when the commissions would give a particular weightage to the writings of highly qualified publicists. But it draws an enormous importance because they do the real labor of law, I would say.
Yes, that's correct. Now we come to our last question, sir. I think this is a question from a very enthusiastic student in our audience. Their question, sir, is what are the career options or prospects for an LLM graduate in international law? And would you have any guidance for such a graduate from India?
Yes, being myself, I have navigated myself what could be the international law career or international prospects. And I'm very happy for that enthusiastic student because I was searching myself an answer 30 years back. And, that means though I have navigated myself a journey, I'm very happy to answer that question. It requires a whole session altogether. Nevertheless, I can say there are the opportunities as far as careers in international law is concerned are boundless. Only thing is you can't find easily available. So you won't find law firms, you won't find individuals or organizations telling, for example, that please do the work for us. International law is, I personally believe, it is a lot of passion, perseverance, and hard work. And one has to carve out his or her niche. But at the same time, as I say, earlier international law was meant for states, governed by states. Your international organizations, now individuals. So if you are good in international criminal law, you can become, let's say, counsel. You can be a defense counsel or counsel for the victim. And here you do not have to have a particular nationality. You can put up yourself in the International Criminal Court database. The ICC, for example, invites applications from people who have excellent backgrounds, because from time to time, individuals who are affected by the international criminal law will be looking upon assistance like the pro bono, which National Law University students do from time to time. So the international courts and tribunals also invite so-called pro bono or honorary paid jobs from enthusiastic, hardworking international lawyers. I would say, as far as international law is concerned, one has to work through, but opportunities are plenty, because I firmly believe that no transaction nowadays between individual and the state, between individual and non-state actor, is without importance of international law. So it is up to an individual to find out whether a particular relations between individual and state, individual and private actor, other entity, what is the international law? In other words, international law affects our day-to-day lives. And if you want to pursue your career, every single aspect of our daily lives is affected by international law. Only thing is, to find the means and platforms where you can write, you can advise, you can teach, you can do internship, and opportunities are definitely boundless. And as far as myself is concerned, in the Rashtraksha University, we have a Center of International Law. And even for my assignment in the International Law Commission, my colleague, Mr. Digvijay Revatkar, we are giving opportunities not only to the students and faculties from India, but across the globe. Because my mission is also to build capacity among international law fraternity of all the countries. And those who would like to join directly, indirectly with that mission of International Law Commission, I most heartily welcome all of them. They can be in touch with my colleague, Mr. Revatkar. And of course, we can also organize a practical session, or more dedicated session just on the topics of international law as a career for Indian students and scholars. Thank you so much.
That is extremely kind of you to say, sir. Before we end today's session, I must mention the people who have made this event possible. First and foremost, of course, our most distinguished speaker, Dr. Patel. We are immensely grateful for taking the time out from your very busy schedule for this lecture and for sharing your valuable thoughts on many contemporary issues. Your decades of experience has just shone through, sir, in this entire lecture. Thank you so much. I must also thank the Honorable Chief Justice, Mr. S. Manikumar, the President of the Indian Law Institute, Kerala State Unit, for his unwavering support in all of our activities. I also thank Honorable Mr. Justice Alexander Thomas, the Executive Chairman of the Indian Law Institute, Kerala, who is truly dedicated to ensuring the success of this online lecture series. I also thank Advocate Sanjay, the Secretary, as well as all the other members of the Indian Law Institute, Kerala State Unit, for their meticulous planning and organization that has culminated in today's lecture. I must also mention my gratitude to the staff of the High Court, who have ensured that the event was streamed without any technical issues. Lastly, I thank the judges, lawyers, academicians, students, and other members of the audience who have joined us this evening. You have made this lecture a very fruitful experience for all of us. Thank you all. And with that, we come to the end of today's session. I wish all of you a very good evening for the rest. Thank you, sir.
Thank you very much, and looking forward to more interactive sessions in the future. Thank you so much.
Thank you, sir. Thank you.